So multiple cases seeking to strike down a state's ban on so-called assault weapons are now seeking immediate Supreme Court review. And the state has made a critical mistake in response to these lawsuits, which tees up a critical Supreme Court review. So let's talk about what just happened. Now, real quick before we jump into this video, if you agree that these rifle bans and magazine bans are clearly a violation of the Second Amendment, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry a Kershaw Iridium knife every single day for my EDC, and I cannot recommend their knives enough. And right now, if you go to their website and order using the code 2024SCHOLAR40, you can get 40% off of your order. Now that doesn't apply if they're already running a sale, because usually their sales are better than 40% off, so keep that in mind. As I mentioned in the intro, in this video, I have some news for you on the current battles to strike down the state of Illinois and their ban on so-called assault weapons and then also magazines. These current actions could also have huge implications for a bunch of other states like my state, the state of California. The cases we're going to be following in this video are 6 Illinois cases which are ultimately seeking immediate Supreme Court review and Supreme Court intervention on this issue. The cases include the NAGR versus Naperville case, the Harrell versus Raoul case, the Barnett versus Raoul case, the Gun Owners of America versus Raoul case, the Langley versus Kelly case, and then also Herrera versus Raoul. The state of Illinois has now responded to all of these petitions, and they're arguing, of course, that the Supreme Court should not take up review of these cases. However, in this response by the state of Illinois, they make a critical error. They argue that AR-15s and similar rifles are not arms at all under the text of the Second Amendment. Therefore, the state believes that their restriction does not violate the Second Amendment because rifles like AR-15s are not arms. This is a huge error made by the state of Illinois that may drastically shift the scale towards the Supreme Court actually granting review to all these cases. And that's because the state is taking a hardline approach that the Supreme Court might not like. Now, you may recall that recently we received news that the Supreme Court did deny 2 emergency injunction requests, which were asking for the Supreme Court to put a temporary halt on the state's ban on rifles and magazines. Those cases were the Colkins versus Pritzker case, and then also the NAGR versus Naperville case. Like I mentioned, there are multiple other cases which are challenging the state ban. One of those cases is the Harrell case, which is supported by the Second Amendment Foundation, then also Firearms Policy Coalition. Harrell is a case which we've talked about before on this channel, and it was one of those multiple cases that was recently denied 7th Circuit en banc panel review. And it was denied review even after the 7th Circuit 3-judge panel issued a clearly incorrect type of analysis when it comes to applying the Second Amendment. This case started out in a lower court in front of Judge McGlynn, who ultimately did strike down this Illinois ban using a preliminary injunction. The state of Illinois appealed that preliminary injunction up to the 7th Circuit, and on review, a 3-judge panel of probably the most anti-gun judges removed that preliminary injunction and ruled in favor of the state of Illinois. In coming to that decision, this 3-judge panel in the 7th Circuit used an analysis that did not align with either Heller or Bruin. Instead, the 7th Circuit concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. They used the military use test, which does not align with what the Supreme Court said recently in both Bruin and Heller. This is the same test that the 4th Circuit has recently used in the Bianchi versus Frosch case, which also deals with a state's ban there, the state of Maryland, their ban on rifles. In the Harrell case, the question presented to the Supreme Court in response to what the lower court said is whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with semi-automatic firearms that are in common use for lawful purposes. The question also includes that same type of analysis when it comes to the possession of magazines. And how the state has responded to this request is why the court should in fact grant review to all these cases. In the response, the state of Illinois argues that the 7th Circuit was the first circuit court to consider a Second Amendment challenge to a restriction on semi-automatic firearms or ammunition magazines after New York State Rifle and Pistol Association versus Bruin. And the only other circuit court to consider such a challenge after Bruin held, like the 7th Circuit, that the challengers were not entitled to a preliminary injunction. There is thus no conflict among the federal courts of appeal on the question presented. One of the main arguments made by the state is that the Seventh Circuit is one of the only circuit courts right now to even try to apply Bruin to these rifle and magazine bans. And even though maybe they got the analysis completely wrong, the state of Illinois wants the benefit of the doubt for the Seventh Circuit, and they want the Supreme Court to simply just wait for the issue to develop more down below, for the lower courts to grapple with this issue, even though it's been 2 years after Bruin, and maybe gather more evidence. And even if they got the analysis wrong originally, eventually they will correct it, because right now this is only a preliminary injunction ruling. Maybe they're going to get it right on the final merits review. They go on to state that petitioners seek to overcome the fact that this case is not cert-worthy by arguing that the lower courts are disrespecting Bruin and the Second Amendment. But there is no reason for the court to depart from its usual certiorari criteria. It has been less than 2 years since Bruin, and courts are applying it carefully to laws restricting semi-automatic weapons and ammunition magazines, many of which have been on the books for decades. And as the decision below demonstrates, they are doing so in a manner consistent with DC versus Heller and Bruin. Indeed, as the Seventh Circuit explained, the restricted firearms and magazines are not arms protected by the plain text of the Second Amendment. Rather, at least on the record developed at the preliminary injunction stage, they are more like machine guns and military-grade weaponry that Heller stated may be banned. In addition, the Seventh Circuit found the challenged laws are consistent with the nation's historical tradition of regulating firearms. Specifically, to protect public safety, there is a historical tradition of regulating the especially dangerous weapons of the time in the civilian population and reserving them as appropriate to the military and law enforcement, while leaving many other weapons universally available for lawful self-defense. Now, all of this is a very bold position that is being taken by the state of Illinois. Instead of relying just on a historical approach and maybe trying to draw a connection between banning AR-15s and maybe some historical dangerous and unusual restrictions that they can kind of find, the state is simply just taking the position that's even bolder. They are starting from the premise that AR-15s and similar rifles are not arms at all. They are essentially trying to import an analysis into the textual level that makes these rifles fall outside what is considered an arm in the whole arms language in the text of the Second Amendment. By claiming they are not arms, Illinois then moves to the position that as non-arms, the state can itself put whatever restrictions in place that they want and ultimately ban them. What the state is saying here in the response to the Supreme Court is that essentially the Seventh Circuit found that these rifles are not arms because they believe they are the same thing as an M16, and therefore they are not protected as arms under the text of the Second Amendment. But then they say that the conclusion made by the Seventh Circuit was made based on a limited set of evidence that was sent to them on the preliminary injunction stage, and that even if the Seventh Circuit got that analysis completely wrong, they should have a chance to correct that, and that further litigation and further evidence down below in the lower court could correct that issue. Now, the biggest hurdle in this case is the fact that this is still on a preliminary injunction review. That means that these cases are still in an interlocutory posture. FFPC and SAF tried to overcome this hurdle by arguing that, although petitioners are coming to the court on an interlocutory basis, the current state of the courts of appeals on this issue and the patently erroneous nature of the decision below provide good reason for this court to take the case now and settle these issues once and for all. What this means is the plaintiffs take the position that waiting for the lower court to rule in these cases under the already defunct military use analysis is essentially pointless when we already know it's the incorrect type of analysis. Now, what is really interesting with what is now developed in this case is the Illinois response. The state is taking a very radical and hardline approach. Then they're essentially having to adopt what the Seventh Circuit said, that AR-15s are the same thing as M16s, and therefore they can be banned as dangerous and unusual. And these type of semi-automatic rifles, the most common rifles owned for lawful purposes in the millions, are not arms at all. That is the hardline approach they're taking, and that is going to get them in trouble. The Supreme Court has already shown that the textual analysis to determine if something is an arm is simply anything that is a weapon of offense that a person uses to cast or strike another. These rifles here in question are clearly those type of arms. Also, the state is taking a position that these are not in common use, and they're not in common use for self-defense, even though we know that's 100% incorrect. These are owned in the millions by law-abiding people for lawful purposes, including self-defense, this hardline approach taken by Illinois in their briefs might in fact get them in trouble and result in the Supreme Court, at the very least, remanding this case with instructions to the 7th Circuit that they use the incorrect type of analysis and they need to correct it. So that's what's going on in Illinois. The Supreme Court certs are moving along. The cases are also moving along at the lower court level. But the state of Illinois is taking a hardline approach, which in my opinion is very, very risky for their case. So if anything else develops, if anything changes, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.